I'm not going to talk about it. We're running low on time. Very important case. Okay, to the 10th Amendment, which is on the back side of your handout.
And that little frivolous clause, it means nothing.
Some people, including Beck and Tea Party enthusiasts, have the notion that the 10th Amendment to the Constitution, the powers not delegated to the United States by the Constitution nor prohibited by it to the states, are reserved to the states respectfully or to the people. That this amendment resolves all questions relating to the division of power between the national government and the states. And it actually resolves none of those questions. Usually those who hold this view also argue that we have ignored the 10th Amendment in our political and legal considerations, leading to the creation of an overly powerful national government. The problem with this view is that the 10th Amendment says nothing. All it says is that the powers not surrendered to the government of the United States are retained by the states. But of course, before we can ascertain what powers are retained by the states, we need to understand what powers have been surrendered. The 10th Amendment does not answer that crucial question. To answer that question, we must do as we have done here this evening and go back to the text of the Constitution and attempt to construct from that text the powers of the national government. If the 10th Amendment contained one word, the word expressly, then it would mean something on its own, independent of the rest of the text. If the 10th Amendment read, the powers not expressly delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectfully or to the people. And you will note, under the 10th Amendment is very similar to the wording of the third article of the Articles of Confederation. And you will note that word expressly in the third article of the Articles of Confederation. Surely the removal of the word expressly from the 10th Amendment to the Constitution is not accidental. Chief Justice Marshall makes note of this in McCulloch versus Maryland. The men who drew and adopted this amendment had experienced the embarrassments resulting from the insertion of this word, expressly, in the Articles of Confederation, and probably omitted it to avoid those embarrassments. There is an interesting and highly relevant part of the legislative history of the 10th Amendment that Marshall does not cite. Madison, serving in the first Congress under the new Constitution, was the primary author of what we now call the Bill of Rights, including the 10th Amendment. When he introduced these amendments on the floor of Congress, a Congressman Tucker from South Carolina rose to object to the wording of what is now the 10th Amendment to the Constitution. Congressman Tucker wanted to insert the word expressly. Madison responded with an argument that he may have come to regret a few years later. He stated that, quote, "It is impossible to reduce a government to express powers only. Powers by implication, that is implied powers, must be admitted, or else we will be reduced to recounting all sorts of minutiae." Madison's point, end of quotation. Madison's point was that if a body is to create a constitution of express powers only, it will have to be lengthy and detailed in order to account for everything that might prove to be necessary. And even with a lengthy and detailed constitution, something important or something that will prove to be important is bound to be omitted. When Madison finished his response, there was not even a vote on Tucker's proposed change of wording. Tucker's motion died for lack of a second. With some 60 congressmen around him, Tucker could not even get a second. The intent of the first Congress is quite clear on the question of express powers and implied powers. It expressly rejected inserting the word expressly into the Constitution, making the new government a government of express plus implied powers. To illustrate the importance of this wording, there was an infamous 1918 case, 99 years after McCulloch versus Maryland, Hammer versus Dagenhart. This was a case where the Supreme Court, by a narrow 5-4 decision, restricted Congress's use of the power to regulate interstate commerce, to get at abuses and the conditions of child labor. To reach its predetermined decision, the court had to, and therefore did, misquote the Constitution. You know, the text of the Constitution doesn't settle our argument, well, we'll create new text. The court argued that the Constitution carefully distinguishes between the functions of the national government and the functions of the state governments, and, quote, "the powers not expressly delegated to the United States are reserved to the states." The court would finally get this issue right 23 years later in United States versus Darby, when it said of the 10th Amendment that it states, quote, "a truism That which has not been surrendered has been retained. The issues we have discussed this evening, that implies we're near the finish, and we are.